This is the state of Texas versus Seraphin Sotero. You are Mr. Sotero? He's nodding. And Mr. Sotero speaks Spanish fluently.
Yes.
Do you speak any English? A little bit? Muy poquito.
In the opening moments, the case may seem routine, but in reality, Seraphin Sotero is standing at a very critical turning point. He barely understands English, and in front of the court, he is not only facing a new charge, but also the weight of a serious past case that is about to reopen.
All right, let's go on this motion to revoke probation. 18-3049. Does Mr. Sotero waive a reading of this? Can we proceed in summary?
Yes, sir.
In summary, this motion to revoke probation filed on December 17th of 2025 states that on March 1st, 2021, in this criminal district court of Jefferson County, Texas, that you were placed on 10 years deferred or unadjudicated probation for the second degree felony of aggravated assault with a deadly weapon. Is all of that true and correct?
Yes.
Today's case is about a man whose past was already dangerous. He had a previous charge of aggravated assault with a deadly weapon, meaning he attacked someone with a weapon. Instead of sending him to jail, the court gave him a chance. 10 years of probation. But he didn't value that chance at all. During probation, he was caught again driving under the influence, DWI. So not just one, his old crime came back into focus, and a new crime was added. When he was questioned in court, he admitted everything. Yes, he broke the rules. Yes, he committed a new crime. Now the situation is: backhand index pointing right, a past violent crime. Backhand index pointing right, a new drunk driving offense. Backhand index pointing right, and a direct violation of probation. Now the question is: will the court give him another chance, or will this time lead straight to jail? Flushed face. Backhand index pointing right. Don't miss the next part, because the decision that's coming is the most shocking part of this case.
An agreement has been reached between the state of Texas and you and your attorney, where your probation would be revoked because of this motion to revoke probation. You would now be found guilty of aggravated assault with a deadly weapon that you were placed on probation for and sentenced to 5 years in prison. This 5 years in prison would run together with 5 years in prison to the new charge of operating a motor vehicle while intoxicated, which is a new case in 25 CR 472. Is that your understanding of the plan?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand? I am going to follow these agreements. When I follow this and sentence you to 5 years in prison, do you understand you will have no right of appeal of your cases?
Yes.
Okay. I am following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice prison for a term of 5 years. Also, the judgment in this case shall reflect that a deadly weapon, namely it's called a sharp instrument of some sort, was used in the stabbing of the victim in the aggravated assault, and that the indictment states that in the manner of its use and intended use was capable of causing serious bodily injury and or death. Thus, that constitutes a deadly weapon, and the judgment shall reflect that a deadly weapon, namely a sharp instrument, was used in the commission of this crime.
Judge, I know that the court went over it with him in his original plea, and we'll go over it on the next plea, but I don't believe Mr. Sotero is a United States citizen.
Are you a citizen of the United States?
No, I'm a resident.
Do you understand that a felony conviction of a crime in the United States may affect your ability to maintain your residency and may adversely affect the chances that you have to become a citizen of the United States? Do you understand all of that?
Yes.
Do you, knowing all of that, do you continue, do you insist on moving forward with your plea in this motion to revoke probation and your plea in this new indictment to operating a motor vehicle while intoxicated?
Yes.
I find your decisions are made voluntarily, knowingly, and intelligently. And you've had a chance to speak about all of this with your attorney, Mr. Dusler. See, or no?
Yes.
Okay. All right, let's go to 25 CR 472. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In this one, Mr. Sotero, paragraph 1 of the indictment states that on or about January 28th, 2025, in Jefferson County, Texas, you operated a motor vehicle in a public place while you were intoxicated, which is an offense. Do you understand?
Yes.
Paragraph 2 goes on to allege that you have 2 or more prior convictions of DWIs, and that you were convicted in Bayard County, Texas, San Antonio, on April 8th, 2003, in County Court at Law Number 9, for the offense of operating a motor vehicle while intoxicated. Also on April 8th, 2003, you were convicted of an additional offense of operating a motor vehicle while intoxicated out of County Court at Law Number 9 of Bayard County. In other words, on the same date, you pleaded guilty to 2 DWIs and were convicted of 2 separate offenses of operating motor vehicles while intoxicated in County Court at Law Number 9 in Bayard County on April 8th, 2003. Is all of that true and correct?
Yes.
Are you pleading true and correct to these allegations in paragraph 2 of this indictment, voluntarily, knowingly, intelligently, and upon discussions with your attorney?
Yes.
How do you plead to this indictment in paragraphs 1 and 2 in cause number 25 CR 472, which alleges that you operated a motor vehicle in a public place while intoxicated and you had 2 or more prior convictions of operating motor vehicles while intoxicated? Is all of that true and correct? And are you pleading guilty to that offense?
Yes.
Also, paragraph 2, which alleges those prior convictions in 2003 of DWI out of Bayard County, are those convictions true and correct as they are alleged?
Yes.
And you are pleading true and correct to all of this voluntarily and because it is true?
Yeah.
All right, this constitutes a third degree felony, which means if convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine up to $10,000 can be assessed. Do you understand the punishment range applicable here?
Yes.
An agreement has been reached between your attorney and the state where you would be pleading guilty to this third degree felony of driving while intoxicated, a third degree felony or greater, with 2 or more prior convictions. You would be found guilty and sentenced to 5 years in prison to run concurrently with the previous 5-year sentence. Do you understand?
Yes.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes.
Show you what's marked as State's Exhibit 1. Did you sign that voluntarily? Understand it? Discuss it with your attorney, or the contents true and correct?
Yes.
State's Exhibit 1 tendered into evidence
No objection.
without objection admitted. Among other things, sir, this states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you, or you've read it. You were guilty of this crime, the third degree felony, driving while intoxicated, with 2 or more prior DWI convictions. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes.
State's Exhibit 1 is part of the record without objection.
No objection.
It is admitted. Pre-sentence report is waived
Yes.
here. I'm going to follow this agreement, sir. I'm going to find that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. You know what you've been charged with. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this third degree felony. I now find you guilty beyond a reasonable doubt in paragraphs 1 and 2 of this indictment, the third degree felony of driving while intoxicated, a third degree felony, and I am following this agreement. You were hereby sentenced to confine in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. This sentence shall run concurrently with cause number 18-304. 8-9, this aggravated assault probation that was revoked that we sentenced you for earlier today. Do you understand all that has happened?
Yes.
Anything else to add?
Yes, sir.
Defense?
Oh, yeah.
We are in recess on this. Thank you. Good luck.